Tony, let's go on the record on cause number DC 201463, JAG Financial Services LLC versus Capital Asset Recovery LLC. Counsel, make your appearances.
May it please the court, good morning, Your Honor. Tom Melsheimer on behalf of Carr, and I'm joined here in my office by Grant Schmidt.
Dana Ramsey, Your Honor, for Brian Glasscock, and I believe Miss Misty Broom is also attending.
Yes, Your Honor. Constance Broom also on behalf of Mr. Glasscock, but I will not be arguing today.
Anyone else? All right, let's get started.
Thank you, Your Honor. May it please the court. This is a summary judgment brought on behalf of Carr, but it is not seeking to dismiss the entire action. Rather, it is only seeking to dismiss claims brought by a third party in this case, and that is Mr. Glasscock. This is a motion that, if granted, would greatly simplify the case. I also think it would put the case in a better position to potentially be resolved. Why waiver, Judge? It's a summary judgment on waiver. Mr. Glasscock has a claim that alleges that Carr breached a partnership agreement with him by not providing him partnership distributions in a alleged partnership interest starting over 10 years ago. So we think that this claim has been plainly waived under Texas law. And Your Honor, admittedly, waivers often a fact issue, of course, but the Supreme Court has noted that it can be, in the right circumstances, established as a matter of law. And I think this is an example of one of those cases where it's been established as a matter of law. First, Mr. Glasscock was a partner starting in 2003 at Carr. And from 2003 to 2009, he received K-1s and partnership distributions. And as this is not in any way subject to dispute. Your Honor knows that when you're a partner at a law firm or anywhere, any kind of business, you get a K-1, and that captures the partnership's income, losses, deductions, distributions, and more. And you need a K-1 if you're a partner to file your income taxes. And even if you've got some other side agreement about your partnership interest or something, if you're a partner, you get a K-1, and you have to file that K-1 with your 1040.
Are there any Texas cases that say that in order for you to have a partnership interest, you have to have filed the K-1? Is that a factor? Is that dispositive? I know that's a big part of what you're arguing, but
yeah, I don't, Your Honor, I don't know of a Texas case that says you have to have that. But so I think the answer to your question is I'm not aware of one. Our issue with the K-1 though is it is the indicia of being a partner from a distribution standpoint. Everyone that is a partner knows that you have certain tax obligations as a partner, and you get a K-1 to reflect that, and you file that with your 1040. And certainly if this had been a matter of not getting one for a year or two or 3 or 4 or 4 or 5, maybe we'd have a different case to argue. This is 10 years, and I'll just direct the court to the one answer to this is 26 USC.
But doesn't the other side or the respondent argue that they were getting distributions, they just weren't called partnership interest distributions, and that this was kind of how the your side wanted to do it, is that they didn't want it to come as a partnership interest, but they were being paid in other ways, and there wasn't really a waiver?
Right. So that's true. You know, that's what they argue, but that doesn't get them there, I don't think. That's absolutely what they say. But if you think about it, whatever they're called, if he's getting any benefit income from the partnership, he's got to report that and he's got to get a K-1 to report it. And remember, the K-1 doesn't just talk
But
about.
is this a tax case that we're hearing, or is this isn't a tax case that we're talking
No,
about?
it's not a tax case, Your Honor, properly noted. But we've got a guy that let's back up. We've got a guy that was for 10 years, never said he was a partner, never complained about anything with respect to not receiving his tax documentation. This lawsuit comes up.
Well, he is saying that they told him he would be paid in other ways.
Well,
for
but
his
Your Honor, if
partnership
that's
interest, right?
true, okay, if you assume that's true, and which of
I'm
course,
not, I mean, I kind of have to take it as true for a summary
so
judgment.
take that as true. If we roll with that, then he's still out of luck, because if he's getting something from the partnership, whether you call whatever you call it, he's got to get a K-1 reflecting that income. And of course, Your Honor, he was an employee. So, I mean, let's make sure we.
But haven't we already established that there aren't any cases out there that say that in order for there to be a partnership interest, you have to file a K-1?
Your Honor, that's true. Federal law says you have to get a K-1 if you're a partnership. But I agree that there's not a Texas case that says that. But again, we don't have to look at it abstractly, because we look at waiver is, of course, a matter of fact. And so let's look at what the undisputed facts are. For 10 years, let me just add this. Here's something that is disputed. He says, we say we removed him as a partner and he continued as an employee. He says, no, I was always a partner. Okay, that's a factual dispute, and we have to accept that in the light most favorable to him. Okay, well, then where are all the documentation reflecting your partnership interest for that 10 years? And he says there's an oral agreement that there would be, that he would be compensated in other ways. But Your Honor, I would say, again, you have to assume that's true, and you take that in the light most favorable to him. That doesn't make him a partner. That just he was an employee, and he was getting paid as an employee. He admits that he got bonuses. He admits that he got deferred compensation. He also admits that he never received a partnership distribution for 10 years. And I think for him to come now and say, oh, you know what? Now that you've sued JAG, I'm going to third party into this case about 6 months after it was filed. So more than 10 years after he was removed from the partnership, or just put it in the light most favorable to him, more than 10 years after he started beginning to stop receiving partnership K-1s and distributions, he says, no, I was a partner. And so we just think that under the cases that we have cited, trail text being the most important one, that if you believe you have a right to something and you lay behind the log and do not challenge it, that case was 6 years, this case is 10 years. And let's be clear about this, Your Honor.
But what he's saying is that for those 10 years, they were saying, hey, this, according to him, I'm not saying this is true, I'm just saying according to him, and what their allegation is that during those 10 years, these payments that were being made because he was a partner. It's not a situation where he wasn't paid at all for 10 years. He was getting payments during that entire 10 years. They were just telling him it was coming in different ways. Now, there may be some kind of tax consequences to this. I don't know. But it's not like he's just sitting on the sideline out in the cold with not getting anything during that 10 years. Isn't that true?
I would say yes, partially yes and partially no, Your Honor. I think that the yes part is that he alleges that he was receiving certain compensation, but of course he was an employee. He was getting compensated. He was an employee, and I guess our point is, Your Honor,
was there a written employment agreement? Maybe I missed that.
I don't believe there was a written employment agreement, but I don't think the parties dispute that he was the chief COO of the company. until he was fired. So I don't think that's a fact in dispute. Let me say this, Judge.
So you're saying it's an oral contract of employment, and they're saying it's an oral contract of partnership. Is that?
Well, Your Honor, no, they're not. I'll let them say how they want to characterize it. I think what they're saying is, based on his affidavit, that there was a written partnership agreement. They're saying it was orally modified in some way, so that he would not have to get that he was still
Was there a written termination of the partnership agreement?
Yes, Your Honor. He was terminated in writing.
In writing. When was that?
2009, I believe, Your Honor. 2009.
Okay.
And of course, Your Honor, he's not just, and just to be clear, he's not just claiming that he's owed distributions. He says, hey, I'm a partner. I own part of this business. And our point is, you cannot sit back for 10 years and receive no formal legal documentation that is required under federal law for partnership distributions. But again, not just distributions, Your Honor, but of course, anything else related to the partnership. And simply say, oh, by the way, yeah, I know I never got that. I never raised a single issue about it. I never asked about it. I never did anything with respect to that. He leaves the company in 2019, and he doesn't raise this claim until I believe it was the spring of.
I can't hear.
Mr. Melsheimer, you're muted.
Sorry about that. Your Honor, he, just to make sure that you could hear what I was saying. So he left the company in 2019. He didn't raise this issue about his partnership agreement, allegedly that he was still a partner, until he third party claimed in after this lawsuit was filed in 2020. And so we think that on that record, take his statement as true, that he had an oral agreement that he was still going to be a partner. That actually helps our position, Your Honor, I submit, because if that's true, then why wasn't he getting all the, put the distributions aside, why wasn't he getting all the indicia of being a partner, which he admitted he got in the years he was a partner? So he was a partner from 2003 to 2009, and the record reflects that he got K-1s for each one of those years. He stopped getting.
I'm looking at your briefing right now, and it says on page 5 that it doesn't say, at least that I can see, that he ever received a notice that he was no longer a partner. It simply said on January 1st, 2010, Car Holdings LP limited partnership agreement was amended again, and Glasscock was no longer listed as a limited partner. Is that what you're saying was the termination, was that they modified the partnership agreement? He wasn't
correct, Your Honor.
And was he notified that he was no longer a partner?
Both, Your Honor. He was notified and the agreement was modified.
Okay, where in the record does it say he was notified of that?
Your Honor, I'm going to ask my colleague, Mr. Schmidt, to find me that before we're done here, so I can cite that to you.
Okay. Go ahead.
Our point, and I'll close here, Your Honor, because I don't want to take an inordinate amount of time, and I'll save a minute or two to reply at the court's pleasure. But this notion that there was this oral agreement, which the court has to accept as true, I believe that only strengthens our position on waiver, because it does not explain why for 10 years he never sought to exercise any right of partnership, inspection of records, voting rights, distribution rights.
Would he have voting rights as a limited partner?
Well, I don't know that he technically had those rights in this partnership, Judge. I'm just trying to lay out all the different things a partnership a limited partner can ask for: inspection of the records, audit rights, limited rights. All I'm saying is he never did any of that, Judge, because he either knew that he'd been properly terminated, or he just decided, I'm just not interested in asserting these partnership rights. And under Treltex, if you do that for 10 years, I think it's pretty clear that you've waived it as a matter of law.
Weren't a lot of the checks that were sent to him, didn't they say distribution on them when he was receiving the checks from 2010 to 2019?
No, Your Honor. One check said that. One check said that in April of 2017, said the word distribution. So let me answer that.
Okay.
That's 7 years in. So I think we got waiver right there anyway. But distribution, he also admitted, I believe in his deposition testimony, that he did not view that word. He thought that was part of his deferred compensation as an employee of the company, not as a, quote, partnership distribution. But even if you say in April 2017 that was, quote, a distribution, I submit that that's 7 years into this deal where he's acted totally inconsistent with asserting the right of being even a limited partner.
Okay. Response?
Yes, sir. Let's clear up a few things. First of all, in Mr. Glasscock's affidavit filed with the response, he makes it clear that Exhibit 3A, the paycheck stub showing the distribution, is one of the checks he received showing the 2% distribution. As an example, saying, I received pay stubs year after year after year saying distribution on them. Number two, there is nothing in the record saying that Mr. Glasscock was notified of CAR's changing the partnership agreement to try and cut him out in violation of the express terms of those agreements. There is nothing in the record saying that he was notified of that until this lawsuit was filed, and that was eventually, long after we asked for it, eventually produced by CAR, this purported amended partnership agreement. I think it was last fall was the first time Mr. Glasscock even saw that. And that issue is before this court, is not even an issue in the summary judgment. Mr. Glasscock is suing to recover his 5% interest, which is separate from the claim for the unpaid distribution.
So the strongest argument I think that Mr. Melsheimer has made is the argument that back in 2010, he was notified, I don't see it in the record, but that he was notified that he was no longer a partner and the partnership agreement was modified to take him out as a partner. What is your response to that?
That Mr. Glasscock, and that's what a trial is for, will testify under oath that he was not notified of that action. What he was notified of, and again, this is why this is a fact issue, is the constant communication. You understand this is a small company. They're all 5 feet away from each other. So constant communications with regard to the financial condition of this company and their ability and inability at various times to pay or not pay distributions. And what the agreement was, number one, again, he was never told about this amended partnership agreement. And Exhibit 2 exemplifies this because it is a memo, an email that Greg Green wrote to.
I'm sorry, Ms. Ramsey. Are you referring to their Exhibit 2 or your?
No, my Exhibit 2 on our response.
Okay, let me pull that up real quick.
Okay. I might have it on share screen. I'm disabled.
Oh, sorry. Let me go ahead and enable that for you. Just a second. Go ahead.
See if I can find it.
Is that the deposition testimony?
No, it got lost trying to catch on Zoom. Exhibit 2 to our response is an email from Greg Green to the CAR's accountant and Brian's accountant.
Okay.
Now, critically, Mr. Glasscock is not copied on this email. And number one, the email demonstrates the deferred compensation agreement. It confirms what Mr. Glasscock testified to in his affidavit and will testify to at trial, that Carr had told him and the others that they had financial problems, were not able to make the distributions, but they came up with an alternative plan to at least get him 2% and then defer the 3% until Carr had the financial wherewithal to pay it. Now, part of the why this is a fact issue too is Sam, who's on this email, is Carr's accountant, and he also did Brian Glasscock's taxes. So Sam, again, is probably 5-10 feet away from Mr. Green and the others, and would just reach over to the desk and he could get Brian's K-1 to finish the tax returns. While Sam never told Brian that he wasn't getting K-1s, because Sam was told by Mr. Green that they were going to treat his 5% as an economic interest, and therefore a K-1 would not be required. So there's no reason for the accountant to say, Brian, I can't do your taxes because I don't have a K-1, because Sam is being told in an underhanded way that Brian really doesn't have a equity interest. He has an economic interest. So don't worry about the K-1, but we're going to do a deferred compensation arrangement where we're going to pay him the 2%.
Well,
and then
let me ask this,
3%.
because so you're saying he never got notified. Mr. Melsheimer said that he would, and I don't see anywhere in the record that he was, but Mr. Melsheimer says that I was missing that, which is very possible. I'm not criticizing Mr. Melsheimer, but Mr. Melsheimer, can you point to me where in the record he was notified that his partnership distribution was terminated? Just so I can look for it. You're muted again.
I want to correct something that I said. I thought that was part of Mr. Green's declaration. It's not. So let's just be clear.
So there is a fact issue on notice then.
There is a fact issue apparently on whether I don't think he disputes that he was notified, but we did not prove up that we notified him. So I want to correct the record on that.
Okay. I appreciate it, Mr. Melsheimer. Go ahead, Ms. Ramsey.
It is also not cited in the motion any federal law, regulation, or statute. So it's not before the court saying a K-1 is required, number one. So that is not in this record either. They cite one case, Your Honor. So one to throw out Mr. Glasscock's claim based on one case, where in that case, the individual suing to receive a commission never received any money. That does not apply to this case here, where Brian Glasscock was receiving his 2% distribution year after year after year in exact accordance with the oral agreement. So there is nothing to complain about when the other party is doing exactly what they agreed to do. And when his employment was terminated, this lawsuit was filed, starting with JAG, and Carr brought Brian in. He's like, you're going to have to pay me the rest of the money you owe me. That's what this is about.
Okay. Anything else, guys?
Your Honor, let me just add, and thank you. So I think now the parties I have properly stated what the record is. So appreciate you letting me clarify that. I'll say this, Judge. He is never characterized. So like he got a bonus. Okay. So again, he was an employee. No one disputes that. He can get bonuses. He can get deferred compensation. He has never once said in this 10 years that I am being deprived of my rights. And you say, okay, well, you don't have anything in the record about being notified. I think he denies being notified. But remember, I think you have to look at it on both sides of this. He got all these things between 2003 and 2009. He got K-1s, then he stopped getting them. And even if you take his oral agreement, the oral agreement wouldn't have abridged the rights to, and he doesn't say it does, that it wouldn't have abridged the obligations that a partnership would have to a limited partner with respect to reporting obligations like K-1. So our point is,
I guess maybe I'm missing what as a limited partner. So he's getting money at 5%, as I understand it, approximately. which would be his partnership distribution. If I understand the facts, he was listed as a partner. He never was notified, or at least there's a fact issue on whether or not he was notified that he was no longer a partner. He continued to get paid money at about 5% or at 5%. What else was he supposed to do? He doesn't have voting rights as a limited partner. What else? I guess because he didn't get a K1, he should have. I'm not exactly sure what he didn't do that a limited partner would do in this situation.
Well, Your Honor, I would say first, it wasn't 5%. I think he admits it was 2% in his deposition.
Okay.
And I think that is in the record, number one. But number two, I guess what we're trying to hang our hat on here is the change in circumstances from assume he didn't know, assume he wasn't notified for the purposes of this. I think we're going to be able to prove up that he was, but assume he wasn't. He went for 6 years getting all these indicia. Then he didn't get them for 10 years. And you say, well, what could he have done? Well, there's a lot he could have done. He could have said, where's my K1? Why aren't I still getting what I got for the 6 years when I knew I was a partner and I'm not getting something for 10 years? And he does not allege this oral agreement somehow.
Doesn't Ms. Ramsey say that the accountant, maybe I misunderstood, did you say the accountant for the company was doing his taxes?
I think
Yes.
I think they shared an accountant, Your Honor. But again, that also to me, that cuts in our favor, because again, I'll just leave you with this, Your Honor. A man is operating under a set of circumstances for 6 years where he's getting K1s and other indicia of being a partner. Okay. Then for 10 years, he doesn't get those things. He never raises a peep about it, never claims he is a limited partner during those 10 years, never wonders or raises anything with the company. And then 6 months after this lawsuit is filed, where his name is mentioned, he says, wait a minute, now I want to claim my partnership interest. And I think, Your Honor, under Trailtex and others, that is waiver as a matter of law. And that's our motion.
Let me ask this real quick. When are y'all set for trial?
December 6th.
Okay. And do you have mediation coming up on this case?
We've already done mediation.
Okay. So what I'm trying to figure out, I was going to probably take about a month or so to kind of take a look at this before I issued a ruling. But I just wanted to make sure there was nothing that was urgent on getting the ruling. It doesn't sound like there is.
No, and Your Honor, if I may, one thing on, if you would look at Exhibit 3A on the check, it's not a check for his compensation as an employee. It is an entirely separate check solely for one purpose, and it's noted on their distribution. It's the only payment being made clearly under the term distribution. And it's inconsistent with, and he said, this is one of the many checks I received, consistent with the agreement to get this 2% ongoing and defer the 3%.
I'm looking at this. Maybe I may be missing it. Where does it say distribution?
Under earnings, the left column.
I see. Okay.
And Your Honor,
see, if you look at the check, the total amount is $1,400 minus taxes with taken out. So it's not like this is combined with his monthly or bi-month weekly employment check. It's a completely separate check solely dedicated to paying his distribution in accordance with the agreement they entered into year after year after year. This is what he got.
Okay. Let me get to the next hearing.
can I just direct the court, Your Honor, to one other record? So it's their Exhibit 1, his deposition, page 55, line 19. His deposition, Glasscock's deposition, 55, line 19, where he says when he saw distribution, he did not say he viewed that as a partnership distribution. He said he viewed that as anything other than his salary, which could have included bonuses, which is consistent with his occasional receipt of bonuses. So that's That's not an argument. That's just a reference to 55, page 55, line 19.
All right, thank you guys. Great
Thank
briefing
you,
on
Your
both
Honor. I
sides.
appreciate
Thank you
your
for getting me a
time.
notebook, and we'll try to get you an order within the month.
I appreciate
Thank
it,
you.
Judge. Thank you.
Thank you, guys. Okay, I think we also have a continuance motion as well. Is that correct here?
Yes, Your Honor.
On the Capson case.
And we are all here.
Both sides here. Okay. All righty. So let's hear your argument on the continuance.
Yes, Your Honor. This is, we're back again with this, what is a complex fact issue in this commercial construction action that requires full discovery. Discovery deadline is not even until July 30th, 2021. We have more than 2 months left of discovery. We have a mediation coming up on the 28th or the 21st of this month. We believe that these are premature. We have not had both summary judgments by CNC Texas Concrete Pumping as well as Big D Concrete are premature. There has not been adequate time for discovery, and we need additional discovery. This case has been only on the court's docket. It's less than a year. It was filed on May 27th, 2020. We have taken some depositions, most recently the deposition of Alejandro Vasquez, who was my client's subcontractor for the labor for the concrete. And his testimony implicates both Big D as well as CNC. Likewise, our expert has reviewed the materials we received only 3 days before Big D filed its summary judgment. They produced more documents upon which they're relying in their summary judgment motion. And those very documents implicate their issues with Big D and whether they can be found liable here. Additionally, both parties are in this case because they had collection suits that were consolidated by plaintiff into this case. So they're really not going anywhere right now. And we have the right to take depositions of all of their personnel. So not only did Big D serve documents that it's relying upon 3 days before it filed its motion, but after the motion was filed by CNC, we noticed the deposition and they immediately quashed it. So they're both prejudicing us by preventing us from getting evidence to establish our claims against them. We think we need more time to take the depositions. We have Big D's deposition coming up on the 17th. We have plaintiff's deposition coming up on the 11th. And I had noticed CNC's deposition for the 19th, but that's quashed. So we're going to have to file a motion to compel, as well as a motion to compel other documents that they have yet to produce.
Response? I'm sorry, go ahead.
Without that evidence, we're being prevented by these parties from establishing the facts we need to go forward and prove our causes of action.
Response?
Judge, this is a level 2 case, and before only recently did the court sign an order pushing back the deadlines. So the rule is whether or not they've had adequate time for discovery. Well, the discovery period under level 2 would have ended a couple of weeks ago. And so there's really no reason that they couldn't have done whatever it is that they're saying that they need to do now before.
Well, they say they have depositions scheduled that still haven't been taken. What do you say to that?
Why didn't they do it before? There was nothing preventing them from doing that for the 9 months that this case was, 10 months that this before the discovery deadline passed. I mean, Judge, this is an insurance company that has dragged us into this lawsuit. And they filed this lawsuit against us. They should be able to come up with some evidence one piece of evidence that we did something wrong. And so we're going to hear on Monday whether or not they were able to come up with that one piece of evidence. They have filed their response to the motion for summary judgment. The only reason we're here now is if they get to try to kick the can down the road any further. Well, we're tired of them kicking the can down the road. You know, CNC is as far as the equities are concerned, all we do is flip a switch to start the concrete to pump it. That's all we do. And for them to sit there and this lawyer and this law firm does it, they've done it to another one of my clients. They sue everybody that has set foot on a project. And we have to sit there and defend the damn things until the time period for discovery has passed. And you darn right that I sit here with my eye on the calendar, watching for the very last minute the very first second I have a chance to file a no evidence motion, I file it. And we have a right to be heard. Yes, we're still going to be. I tell you what I'd like to do is get the motion heard Monday, get dismissed the heck out of this case, and be able to go back to my old case and file my motion for summary judgment there because the man owes us the money.
Your Honor, if I could step in, this is Haven Massey. I represent Big D Concrete, another third-party defendant who has also filed a motion for summary judgment that's set on Monday. And I just wanted to add that, yeah, while they definitely could have done this discovery, the additional discovery they're seeking will not affect their affirmative claims against us. And I say that because they have claims for breach of warranties, strict products liability, and negligence. The breach of warranties cause of action required that they prove contractual privity. It is indisputable that we are not in contractual privity with them. We are in contractual privity with Capson Development. The strict products liability requires they prove that our concrete materials was an unreasonably dangerous product. Even if the concrete was defective, it is not.
Are they only moving for continuance as to one of the summary judgments or both the summary judgments?
Both.
Okay.
And so they have to prove an unreasonably dangerous product for concrete materials, and that's just not applicable. And then for negligence, they have to prove that we owed them a legal duty despite not being in contractual privity with them. And them seeking additional discovery, trying to prove that our concrete was defective, they may get that, but that's not going to change the fact that they're not a proper party to bring a breach of warranty cause of action, a strict products liability action, or a negligence action. Capson is the proper party to do that, and they have done that. And we're not seeking summary judgment on those. If they obtain more evidence and prove that the concrete was defective, that will support their defenses to Capson's claims, but they wouldn't have affirmative claims against us. Capson would be the one who would come after us, and those causes of action would still be pending even if you grant these motions.
Okay, I'm going to go ahead and I understand this. I understand both sides. I understand Mr. Peoples, Mr. Massey, your frustration, and you want to get this done. And and I understand that. I typically, on a situation like this, where there's still time left on the discovery period, and there's still depositions that need to be taken, I typically do grant continuances. That being said, you need to, actively pursue this. You kind of get one shot. So you said you have a deposition set when, Mr. Granite?
Yes, sir. We have the deposition of plaintiff scheduled for Tuesday, the 11th. We have the deposition of also a corporate representative plaintiff. We have a deposition of Big D, a specific person from Big D who was on site, as well as a corporate representative on the 17th. We do not have one set for CNC Concrete because Mr. Peoples quashed that when we served him with the notice. So we're going to have to file our motion to compel.
Judge, he's not going to have to file a motion to compel. I didn't think it was the right thing to do to produce this concrete man 2 days before the mediation.
Yeah.
Before the mediation or the summary judgment hearing?
The mediation.
Okay. When is the mediation again?
It's on the 21st, Your Honor. May 21st.
Why don't we do this? Why don't we reset this summary judgment? It sounds like you should be able to get this all done by, let's say, late June. So let's reset the summary judgment to, that is June 28th sound.
That would give us an extra, that would work. I think we should be able to, we're also trying to get other depositions of independent witnesses. It's becoming difficult because they're lawyered up, but we'll work through that. The June 28th.
Does that work for you, Mr. Peoples, Mr. Massey?
I am free, Your Honor.
Yeah, Judge, that's fine.
All right, let's set it for June 28th at 10 o'clock. Chris, can you go grab Rhonda?
Your Honor, I can resubmit the order. I have an order with dates in it that I submitted that have the date for the rehearings of the summary.
Well, I just want to make sure the hearing next week gets canceled.
I see.
My coordinator.
I will revise these and send them to you.
And go ahead and when you do that, put on the order that it says on May 7th, I consider the following motion. It makes it a lot easier for me to make sure that this is the correct order. And then put in the order also that this has been continued June 28th at 10 o'clock. So yes. The Kapsen motion for summary judgment that's set for next Monday, it's KAPSEN, set on Monday, has been moved to June 28th at 10 o'clock. So go ahead and take that off the calendar. Okay. All right, guys. Good to see you, and good luck with your mediation.
Thank you, Your Honor.
Thank you, guys. Okay. Next, we have Thomas v. Campe. Anyone here on that case? Thomas v. Campe? Mr. Brackett, you're here on that case?
Yes, Your Honor.
Okay. Let's go ahead and proceed.
Thank you, Your Honor. This is just a motion for citation by publication, unknown heirs. This is a interpleader action where we're trying to interplead excess proceeds from a foreclosure sale into the registry of the court. And we've sued the known heirs, including the lien holders, which is the IRS and HUD. I believe their attorney was online on this earlier. We're just simply asking that we be allowed to give notice to those parties, potentially because there's no probate open for one of the borrowers who's deceased, that we notice them by publication, and on down the line we do the light of appointment.
All right, response?
Your Honor, this is Brian Stoltz. I'm attorney at the U.S. Attorney's Office for the IRS and HUD. We have no objection.
Okay, I can barely hear you, but I think you said you have no objection. Is that correct?
Correct, no objection.
Okay, perfect. All righty. So we will go ahead and allow that. So usually with one of these motions, we usually appoint an attorney ad litem.
Right.
Did you file a motion appointing an attorney ad litem?
I hadn't done that yet, Your Honor. I was waiting on the court to grant this first and for that to be completed. If you want me to go ahead and file one, I can go ahead and do that, though.
Okay, I'd suggest that. It just makes it go a lot quicker. And this was on the Thomas v. Campe. Let me go ahead and put out the order. Genesis, I just printed out an order. Can you go get it from Rhonda? Okay. We'll go ahead and sign that and just get us a motion to appoint guardian ad litem as soon as you can. Or attorney ad litem. All right. Thank you, guys.
Thank you, Your Honor.
Our next case that's on the docket is Primentel versus Hamza. Anyone here on that case?
I'll get it to you. on behalf of the plaintiff, Pimentel.
Yes, yes, Your Honor. And Jack Witham on behalf of the defendant, Hamza.
Okay. All righty. So this is one where apparently or allegedly the plaintiff didn't answer discovery. Is that correct?
Yes, Your Honor. That's the understanding. This is an auto accident case from data loss of August 16, 2017. The plaintiff, Ms. Pimentel, brought suit for her, but also as next friend of a minor. My motion to compel is the responses as to the minor. My understanding is we served on September the 9th, 2019, discovery requests for Ms. Pimentel and then also to the minor through Ms. Pimentel, and we have not received the minor's responses. I've included in the exhibit the discovery requests that we're seeking. There may be some confusion or misunderstanding in terms of I'm a newer attorney to this file. Mr. Getachew, I believe, has indicated that he got on the file in October of last year. I spoke with Mr. Getachew on March the 9th, trying to get regarding the discovery of the minor, sent a letter to Mr. Getachew as well on March the 17th, and then an email on March the 20th, or on March the 18th, to address the discovery from the minor. We did take the plaintiff, Miss Pimentel, the adult, her deposition, and we discussed the need, or at least I referenced the need for the minor's discovery responses at that time. The deposition, I would believe, was taken on May the 7th. And so, Judge, we're just asking for responses to the discovery within, whatever time frame you believe is relevant. We're requesting 10 days from today, but obviously whatever you believe. And then we are also believe they've waived any kind of objections there as well.
Response?
And with that, I request the order be entered to compel the discovery, Your Honor. Thank you.
Okay.
Yes, Your Honor. The issue here is that previous counsel had responded. I believe they served in September 19 of 2019, and we responded on the 26th. Now, the responses in regards to the plaintiff, Pimentel, was also as next friend of the minor. So when I got on board, Your Honor, there was an issue of what discovery was served on the plaintiff and which one was responded to. Now, since previous counsel was the one that got served the discovery, I discussed with opposing counsel, and we were never able to get the discovery served on the alleged defendant minor. And on the conference letters, it's just a blanket request to respond to discovery on the minor. It doesn't reference specific questions or specific discovery requests not responded to. For that reason, we were unable to respond. We don't think this order is necessary. I've advised Mr. Witham that we'll respond if it was served on time in a proper way.
Okay, so response to that?
Well, Your Honor, I'm just looking here for my motion. As the exhibit indicates, and that's what I can go on at this point, is that this discovery request concerning the minor was served per the certificate of service to plaintiff's counsel at the time of September 19th, 2019. There's been no file of designation of lead attorney for Mr. Getachew since he apparently took over. But what I'm going on is the certificate of service that said this was served on them, on the plaintiff. And so regardless of who the attorney is, I believe it's with the same firm, Kelly Law Firm. The information I have is that they should have received it.
And are you saying, Mr. Giddichi, you did not receive it, or you just don't know?
No, the issue is we never had a meaningful conference with opposing counsel. We never received a copy of what was served on the minor until the motion is filed, Your Honor. So if we have responses on the September 26, 2019, and the issue was what was served and what was responded to. So until I got that what was served onto previous counsel, I was never able to properly respond, Your Honor.
Okay, so I'm going to just order you guys to respond within 21 days of this order, and no sanctions or anything like that. And I'm not going to do a waive, because it seems like there's someone. I'm not going to waive objections either at this point. You can bring that up later if it comes up. All right. Anything else, guys?
Thank you, Your Honor. One thing, just housekeeping. This matter has a trial setting of July 13th, and I looked at the matrix, and it doesn't look like Your Honor's having trials until maybe the next week on the 19th, or that matrix online.
Yes.
So I'm just wondering if there's an update on that.
So let's see, what year is this case? It's a 2019. What we would probably do is we would probably just set you the next week. That's what we're typically doing, and so your case would be bumped a week, and you guys would hopefully go to trial the next week.
And Your Honor, if opposing counsel is not opposed to it, resetting the trial because of the discovery issues would be, I think, appropriate in this matter.
Well, I would like to to think about that, because it's been pending. So I don't.
So the way I would handle that is,
go ahead.
Just like I would normally, is that if you have a agreed continuance, file an agreed continuance. If it's an opposed continuance, file an opposed continuance. I am requiring most of these to be set for hearing, just to talk about when the trial setting will be, if we want to continue. And so I would encourage you, if there's not an agreement, to go ahead and just file a motion for continuance, and then let's, move it down the road.
Okay.
Thank you, Your Honor.
And,
All right,
and
guys,
one more
anything?
thing, Your Honor.
Okay.
I'm sorry. Would you like I filed a proposed order in blank. Will you fill that out, or do you want me to see?
I already
another
filled it
proposed-
out. I just signed it.
Thank you, Judge.
Okay. Anything else, guys?
No, Your Honor.
Your
All right,
May we
thank
be
you.
excused?
You may.
Thank you.
Okay, I think we have one more hearing. It's 11 o'clock. Are everyone here for that hearing?
Defense is, Your Honor.
Plaintiff is, Your Honor.
Pilot's here, Your Honor.
Who is the last person?
Pilot Travel Centers.
Okay, and that's on Granger v. Carter?
Yes, sir. Yes, Your
Okay.
Honor.
Oh, we have a Brian West. Is he on this case too?
Your Honor, he is with my law firm.
Okay. Okay, let me go ahead and get started on this one. Give me 1 second. Tony, let's go on the record on cause number DC 2014959, Granger v. Carter. Counsel, make your appearances.
Houston Smith for the plaintiff.
Aaron Rowland, attorney for PPS Inc., Premier Protective Security, and Mark Anthony Carter.
Mark David Seymour here on behalf of Pilot Travel Centers LLC.
Okay, we're here on an in-camera inspection. Is that correct?
Well,
That's one of them.
yes, Your Honor. I think there's two matters. The in-camera inspection, I think we submitted to the court for documents for in-camera review. And we are also here on the defendant's motion to compel
I'm okay if the court just can consider both of them, so we don't have to interrupt. But again, it's the court's call as how it wants to proceed.
Are y'all okay with that?
Yes, Your Honor.
Yes, Your Honor.
Okay, let's, you guys go ahead and move forward with this, and we'll go kind of in the order that we, what I think I'm going to do, because there's going to be an in-camera inspection, is I'm going to go ahead and turn off the YouTube, because I don't want there to be any confidential information shared on YouTube. So anyone object